they don't realize that a lot of employees don't have an appreciation for what may create a lot of legal exposure to an employer. Employers are not, it's not on their radar that they're watching for negative comments about where an Asian might be from as it relates to a concern of the coronavirus. Comments in a workplace about, hey, do you eat bats? Comments in a workplace about whether it's the Kung flu. Just because those types of comments might be said on television or in commentary doesn't mean an employee won't find that type of commentary to be offensive. And so a lot of employers are getting to be very proactive and either doing a short training or disseminating a memorandum to the employees or an email saying no commentary or jokes about ethnicity, food eating, or other types of commentary that could be construed as offensive towards the origin of a virus should be joked about, commented about, or discussed in the workplace. And while an employee might think that they have the ability to discuss political views, that may be true, but they don't have the right to say something that might be offensive in a workplace. So it's very important that the employer be aware and sensitive that maybe some additional training, maybe a memo, maybe an email, and certainly maybe a change to a handbook might even be necessary in light of the current times. And employers, if you ask yourself as a business, you say, well, are employee complaints on the rise or employee complaints on the downturn in general? Well, what we've found as a law firm that focuses this area in 3 states, employee complaints are on the rise, not just because you have issues like the Black Lives Matter movement, where people are a little bit more empowered to make complaints and concerns, but you also have concerns that employees don't have the same restraints they used to have. Employees are frequently working virtually now. And what does that mean? They're not worried about complaining and facing a coworker. They're not worried and about complaining and facing the manager who might retaliate against them. All they have to do is send a quick email and they don't have to face anyone these days. And so employees are much more inclined at this point in time to make complaints. And then an employer is in a situation where they have a legally protected discrimination concern in their hands. And just to drive the point home in one last part, I asked our intake team for just a couple of examples and how many times we've been called this week about issues. And just this week alone, we have received 3 calls and from a New Jersey tech company, from a big pharma company, and a public accounting firm, not the corporations, but individuals wanting to explore their legal rights because email jokes were going around about the Kung flu that they found to be offensive, or another issue about one of them talking about their food stinks that they were heating in the microwave. And these aren't line level employees. One was a CFO, one was an IT administrator, and one was a sales rep. So being very cognizant of making sure that you're updated as an employer on your training can prevent a very serious ripple in the workplace of morale and potential concerns of employees complaining of discrimination unnecessarily.
And before we jump to the next slide, I'm hearing an echo on my phone. A lot of people think as the EEOC as a resource for employees in particular, but the EEOC is actually very employer friendly and provides literally on their website practical tips for employers in the midst of this pandemic to kind of reinvent themselves with compliance training, promoting a workplace for culture and respect. And the EEOC is actually more active recently in the midst of this pandemic with some of its statements, cautioning against discrimination against certain classes of individuals and guidance to employers than it's been in the last 10 years. So Ari and I would both encourage anyone in the human resources area or management area to take advantage of the EEOC's website and the resources available, not just for employees who believe they've been a victim of discrimination or want to pursue a complaint, but to employers to take a hold and print out the practical tips and guides that they provide. What Ari and I are going to talk about next are, the misperception that employers are trying to protect, older employees or pregnant employees in the midst of this pandemic.
Yeah, unfortunately, we've all heard the phrase, sometimes no good deed goes unpunished. Now, of course, the majority of discrimination is intentional, but a lot of it is unintentional and originally based upon something that was well intended. So in other words, let's assume you as an employer, you have management who just really worries about their employees and they really care, but they have no intention to discriminate. That doesn't mean the company can't ultimately be sued for discrimination, because even the local management or the mid-level management or the highest levels of management can engage in conduct that very well violates a state or federal law with the best intentions. By that, I mean, let's assume that you have management who says, hey, you're 7 months pregnant, maybe you should take the furlough first in light of this pandemic. Or you say, hey, you know what, you're in the age group, you're 65 years old, maybe you should take the time off. I'll keep so-and-so here, that way you're not exposed to the coronavirus. Well, that is very well intended, but that certainly may come back to haunt the employer. And I think that from a standpoint of best practices, no matter what, there should always be management training to avoid any reference to any personal or age-related or pregnancy or health-related criteria. And too many managers don't realize that. Not a week's going by where we're not getting 5 to 10 calls that someone was told that they should take time off as it relates to their health or them being predisposed or potentially having an underlying health condition exacerbated that management knows about. And unfortunately, in most of those situations, I think the supervisor or manager was fairly well intended. They just were not trained or informed properly by their management. And it's been at least 30 years that the Supreme Court has clarified, back in the Johnson Controls case in 1991, where a factory tried to put pregnant women in a different job because they were too worried that they might be exposed to chemicals from the battery plant. And the Supreme Court ruled that's not up to the employer. You can have the best intentions, but it's still discrimination if you mistreat the employee in assignments of duties or layoffs. So now, on the back end of this pandemic, by the back end, I mean the phase of switching to green where companies are rehiring more. Now we're getting what I would say is a flood of calls from those same people who were suggested that they go out for a health issue, or they were suggested that they go out because of their age classification. And what happens? Now that employee happens to not be brought back, and other employees who were already staying there, who were younger, less senior, without the same pregnancy, without the same health issue, who were substantially younger and far less experienced or qualified, happen to be kept just for continuity of work. And therein lies a very substantial discrimination lawsuit that may be brought. So a high level of training and just reinforcement at the local, lower, and higher levels of management is very important for those unwitting but well-intended management.
And Ari and I are going to this in a little bit, but I mean, the converse for the pregnant employees, which is a hot topic, when you have individuals that are concerned personally about their pregnancy and whether or not they want to continue to work in light of being pregnant, and leaving that up to the pregnant employee, the Americans with Disabilities Act and the Pregnancy Discrimination Act, which allows for potential accommodations for pregnant workers, are still alive and well in the midst of this pandemic. So, we get a lot of intakes from individuals that are pregnant where the employer is not singling them out. Instead, they're giving out, for example, a memo that applies to everyone saying, hey, if you happen to fall into a protected class, certainly feel free to let us know if there's a reason why you feel that you would be more susceptible to COVID or anything we can do for you. And pregnant workers are, for obvious reasons, concerned about working in an environment, being exposed. But that will boil down to a question of whether and to what extent the pregnant person has a disability or has a basis to be accommodated. And that's an individualized question that should be had by the employer and the employee. The mere fact that someone's pregnant and they're overly cautious and say, I don't want to work, that does not require that an employer automatically accommodate them and say, well, because you're pregnant, we're not going to require you out of everyone else to come back to work. That requires a discussion about whether or not that employee may be subject to an accommodation under the law. So when we were discussing this topic today, what Ari and I were, really kind of throwing back and forth to each other were what we call the basics and potentially no-brainers to employers, managers, HR individuals, because the questions when everybody was getting ready to go back to work were, what are we allowed to do, and really, which are the difficult questions, what are we not allowed to do? So this slide, and I would encourage anyone who's interested and is, talking about preparing to come back, bringing your department back, maybe coming back in phases, is absolutely check out the CDC's website. They update it literally every day and update it in terms of what they're recommending to employers, depending on the nature of the work environment. These things are what I call the no-brainers. You can absolutely stress and emphasize hand washing, hygiene issues, and things that kind of make sense in terms of preventing the spread, like social distancing, or talking about, who's going to come back in staggered shifts. For example, Ari's at home right now, but I'm at the firm, and we may have, 2 of our entire staff here on a rotating basis right now as we move into the different phases as ordered by the governor. The difficult questions, which we're going to discuss with you, are things such as, can you take employees' body temperatures? What kind of questions can you ask when people are exhibiting certain symptoms? I do want to talk briefly about the masks, because there's a lot of information about the masks as a debate by individuals on, on news sources, social media. Some people say, it's a non-issue, just wear your masks. And by order of the governor, you're required to wear them in all public spaces now, and even outside if you're not within 6 feet of people. So can an employer require that? Absolutely. What Ari and I as employment practitioners would like to point out is that you are going to get individuals when they're in the office who raise their hand and say, well, I can't or don't want to wear a mask because of health reasons. If they have a particular condition that they believe is impacted by wearing a mask regularly, or what you may find are people saying they don't want to wear a mask because of their sincerely held religious beliefs. And in those unique circumstances, the ADA, the Americans with Disabilities Act, or Title VII regarding providing religious accommodations may come into play, and there may have to be a discussion about the basis for the objection, and then whether and to what extent the individual can be accommodated. So when we talk about no-brainers, these things seem rather easy to do, but there may be certain complicated issues that arise with individuals re-entering the workplace. The more difficult questions come up in the context of, asking questions of individuals. If someone's exhibiting certain symptoms, you want to take body temperatures, what are you allowed to do? And then on the ADA, when I said that the EEOC has become ever more active in guiding employers and employees, they actually issued a full question and answer fact page for all kinds of scenarios that may arise in the workplace in the context of asking questions, taking body temperature, telecommuting, and the like. So the $1 million question is taking body temperature. So as of March 2020 of this year, COVID was declared what's considered a direct threat that may impact, the health of the individuals in the workplace, or an individual in general who has an underlying health condition. And the World Health Organization has declared this pandemic, a national pandemic. So there's a lot of debate when this was, pre-declared direct threat or pre-pandemic about whether or not you could take body temperature, because the ADA does consider that a medical exam that would not normally be permissible unless certain circumstances existed. But the overriding answer is, yes, you can take body temperatures, but the cautionary tale is that a lot of this information is confidential medical information. If someone calls in and says, I need to call out today because, I think that I might have COVID symptoms, it is not incumbent upon the employer, nor is it legal at that point to tell everybody, hey, Susie Smith called in, she thinks she has COVID. You're sharing confidential medical information. And when you talk about the logistics of taking a temperature, having a screener, keeping a log, you're allowed to do that, but the ADA, the Americans with Disabilities Act, still requires that that be contained in a separate medical file. So, an HR individual may say, well, can I just keep a log every day and of everybody that I'm checking, whether they had a temperature or didn't have a temperature? And the answer is take precautions. If you're screening individuals for symptoms, you shouldn't be maintaining information respecting COVID call outs, or, conversations with an employee about potential symptoms in their personnel file. You should create an actual separate medical file. Some employers have said, well, if I have a separate medical file I normally keep for their FMLA documents, or if they've asked for a leave of absence, do I have to create a separate COVID file? And the answer is no. I think that the guidance from the EEOC is simply for employers to make sure that they're not violating individuals' rights against protected health information, which this type of stuff is considered protected health information. Go ahead, Ari.
Yeah, I was going to add in, this is a misunderstanding on the part of a lot of large employers. So for example, we might be in the middle of a deposition and we might say, was all this information in the personnel file? And the HR director or HR manager says to us, yes, this was all the information in their personnel file. And then we ask, was there any other documents kept in any other files? No. Do you keep a separate file for this employee? Absolutely not. And so everything was in this personnel file. Yes, it was. And the HR person unwittingly admitted to violating 2 separate federal laws. And that is at the highest levels of HR. Even if even the chief human resources officers at many companies don't have an appreciation for the legal requirements of a personnel file. And I just think it's important to drive it home as not just COVID related. Under Section 825-500 of the FMLA, an employer is obligated to keep every FMLA form except for general notices in a separate medical file for the employee, or they violate the Family and Medical Leave Act of federal law. Under Section 1630 of the ADA, an employer is required to keep every ounce of medical information, even an excuse note, in a separate medical file for the employee. The purpose behind that is to prevent general management who's performing evaluations from being allowed to see the employee's underlying health conditions, which then breaches confidentiality or accidental disclosures. So it just, whether you're a small business with 10 or less employees or a business with over 500 employees, there seems to be a lack of technical appreciation in the storage of the medical information, even far beyond the COVID-related matters.
Yeah, and that's why when you talk about the plan for preparedness and coming up, with who's going to be part of your COVID precautionary team, I mean, certain information, these other statutes, like Ari brings up, the Family Medical Leave Act or the ADA, they don't go away. So you might want to be careful in terms of who you're picking to be the individual that's checking temperatures, because you don't want to run afoul of the FMLA, which tries to caution against having direct supervisors gather health information or have employees submit certifications. So to the extent that your staff allows for it, and you're talking about a small business that has, an HR rep on site, or even a larger facility that has HR generalists on site, maybe you utilize those individuals to be responsible for temperature checks. I see we have a few questions, which I do want to address in time, because I assume they pertain to this topic, but I just don't want to forget my thought. Beyond temperature checks, there have been questions about COVID-19 tests. Can those be performed on employees? And the answer is yes, because COVID has been declared a direct threat. And then the question that has been posed by employers is, can we require antibody testing? And the answer is no. So at this point in time, temperature checks are permitted, COVID checks for the active virus are permitted, but antibody testing is not permitted. And then there's issues arising where, if in fact we encounter a vaccine in the future, can you mandate that to your employees across the board without exception? And the answer is maybe, or with exceptions, as long as you don't run afoul of Title VII if the individual says they can't get a vaccine for religious reasons, or they can't get a vaccine because of health reasons or a disability that they have. Let's take a look at some of the questions, if I can figure this out in the chat. Ari, what are my options as an employee if I don't feel safe or comfortable going back to work? How should I communicate with my employer? And I think Ari can answer this right now, or we actually have a full slide on what the options are in terms of leave that's permitted and paid leave. Well, I think what we're getting into next is questions in that regard, if you qualify for a disability under the Americans with Disabilities Act. But Ari, do you want to touch upon that generally? Do you want me to reread the question?
No, so the question generally is just, what if I don't feel comfortable returning to work? And that is going to be addressed in a future slide. But in short, it depends. If you don't feel comfortable returning to work, you may have very substantial OSHA-related protections from not returning to work and job protection, or you may very well be allowed to be terminated from your employment if your concerns are not properly grounded in fact, your perceptions of what's going on in the workplace. So I'm going to more fully answer that question as the matter proceeds, and just sort of kick that can down the road with that general answer for now and a very specific answer later. But just following on what Christine had said, I just want to pass along and continue to do our best some really just black letter principles that are just easy takeaways from this seminar. So the answer to the question is, to the question of, can I terminate an employee for wearing a mask, not wearing a mask, or not following safety protocols? Absolutely. The answer is yes. 95% of the time, you can do that. It's very rare that an employee has a justifiable or expressed reason for a medical issue that they can't wear a mask. So if they refuse, you can generally terminate the employee. There's no right of free speech or no constitutional rights in a private workplace. The Constitution applies to federal governments and state governments and municipalities, and it may restrict certain types of things, but the Constitution does not apply to private employers. And so there is no entitlement to not wear a mask or civil right not to wear a mask. Secondly, you might say, well, am I obligated as a business or am I obligated as an employee to follow these safety protocols? The answer is currently yes. There is no state or federal law that requires an employer to implement safety protocols, but as people know, New Jersey Act 162 and the current governor's order, Governor Wolf, do require that you have to mandate mask wearing in the workplace, social distancing, sanitation procedures, and to inform an employee if they come into contact with someone who tests positive for COVID. So there are requirements only currently under the governor's order for those safety protocols to exist. The last point is employer liability. An employer can be sued by patrons or clients that they don't use reasonable care to protect from the pandemic. On the other hand, most employees will ask, hey, can I sue my employer if I get COVID? The answer 99% of the time is going to be no, because if an employer suffers a workplace injury, physical, viral, or otherwise, it's typically barred for every claim except for workers' compensation. So I just wanted to pass along some just sort of lines in the sand.
And I mean, the last thing that Ari mentioned was employees' concerns about wanting to bring private suits against employers for basically failing to adhere to some of the CDC's guidance or state directives or federal mandates. This is one of our last slides, but you know, in case we run out of time, individuals are bringing lawsuits, but as groups, for example, Amazon employees or McDonald's employees, you may have seen them in the news, and you know, they're bringing them under the theory of public nuisance. So, you know, overall, how you operate the workplace and depending on the size of the employer, you know, may signal red flags for employees if they think that there's some flagrant disregard for adhering to CDC regulations. And Ari raised if someone tests positive for COVID, and we were talking about, you know, keeping that information confidential, but an employer is permitted to share a positive COVID test with local regulatory authorities and report it there. If an individual is placed to work with you and they're from a staffing or a contracting agency and they know that an individual's test positive for COVID, they are permitted to inform the employer for obvious reasons so they know who that employee is. And if someone's tested positive, while you're not allowed to share the name with other individuals, if you think someone may have come into contact, then you are certainly allowed to inform others. You know, you may have come into contact with someone that did test positive for COVID. This slide, and just moving quickly so we can get through some of the other topics, speaks to the question that was posed, and if someone's concerned about coming into work. This bleeds into individuals' concerns who do have immunocompromised issues that may make them more susceptible to COVID. And so generally speaking, not generally, you're not permitted under the ADA to ask any individuals if they are in fact immunocompromised that may make them more susceptible. But if an individual themselves feels unsafe coming in because they have any number of health conditions, they're permitted to raise their hand and explore that with the employer. And mere fear or concern, that would not qualify such that someone be entitled to accommodation and not have to come back to work, or would have to be allowed to telecommute if that's not something within the province of the employer's business. I just lost my train of thought.
Well, while you're looking, Christine, we had one question that goes back to a past topic from one of the members of the audience that asks, can we ask employees to take their temperature prior to the entry to the workplace? And not only are you allowed to, but currently under the Governor Wolf's safety order, that is actually a requirement for employers. So it's permitted and it's required, at least as of now.
Thank you, Ari. So, my train of thought, what I was getting to is there's some individuals who suffer from any number of mental health conditions, anxiety, depression, and the EEOC cautions that if an individual, because of underlying mental health conditions, is so concerned about working in light of the COVID pandemic, that may be an accommodation that has to be made for a particular mental health disability if they feel working under those circumstances is going to exacerbate an existing mental health condition. So I think there should be caution and concern, at least to have the discussion for individuals that suffer from mental health conditions, or they come forward and raise their hand and say, I suffer from tremendous anxiety, I treat for it, etc., such that they should be subject to an accommodation.
And the next question that was asked, and we're trying to just sort of answer them if we're able to answer them quickly during the course of the slides, was, are employers obligated to provide their employees with PPE? So in April, just using Pennsylvania as an example, and it's case by case, if there is no local, state, or federal law that requires PPE to be provided, generally speaking. However, there is OSHA requirements that requires an employer to protect their employees, and based upon factual circumstances, PPE might have to be provided under OSHA circumstances. However, currently, Governor Wolf does have an active order in place dating back to April, which he certainly could end at any point. And under one subcategory of that order, it does require that employers offer masks and PPE to employees physically working, to rotate employees where possible, and to engage in other safety procedures.
And I mean, to that end, one thing that employers are encouraged to do when looking at the workplace at issue is to classify your workers in terms of their potential risk for exposure. Some people may be very low risk for exposure. If they're, for example, if we had our front desk receptionist coming in and no one was here, you're working at administrative capacity, versus some individuals may be very high risk for exposure, working in the healthcare industry, or, working in a crowded factory where the assembly line isn't able to social distance in order to get the job done. So OSHA actually has, a pyramid on their website that encourages employers to kind of classify individuals for very high risk down to low risk. And the higher risk that you are, the more that OSHA requires or recommends that you provide certain PPE gear, or if able, barriers to kind of separate individuals.
Now,
go ahead, Ari.
Yeah, so the current slide is really the most common inquiry that we're getting from companies that we represent and individuals. The slide asks or discusses the issue of telecommuting. I don't think there's a week that's going by where our firm is not getting at least 10 calls from employees who are saying, hey, I'm being asked to go back to work physically, but I really want to telecommute. So again, in the interest of giving as sort of clear guidance as possible from a legal perspective, it's pretty straightforward. First of all, if an employee wants to telecommute because they have a family member who might be susceptible by age or health, the answer is they have no right to telecommute. No state, federal, or local laws require an employer to accommodate an employee because a family member might contract a virus. Second of all, if an employee says, hey, I'm in a susceptible age group, it's recommended by the CDC that I telecommute. Unfortunately, no law protects and requires someone who might be susceptible based on age to be allowed to telecommute. So in either of those circumstances, the employer has the legal right to require the employee to physically work from the premises. a lot of employees say, well, I'm worried I have an underlying health condition, and if I have an underlying health condition, I may catch the virus and I could theoretically die. I have COPD, a heart problem, etc. And those are very serious concerns, no question about it. So there's a real debate because there's no current case law on the issue. An employer, their counsel would argue that we don't have a need to accommodate someone because they might catch a virus. We're not technically accommodating their actual disability. We're only accommodating the hypothetical possibility that their current disability might be impacted. And an employer might say, we don't have to do that. That's what we're hearing from defense attorneys. A plaintiff's lawyer would say, no, even if you provide an accommodation in the workplace, that's oftentimes merely a preventative measure, and you have to engage in an interactive process and provide that accommodation. The EEOC, which is not binding on courts, has given guidance that where possible, an employer should accommodate if someone has an underlying disability, or at least engage in an interactive process to determine if that's possible. So it's certainly something to be aware of. If somebody does present an issue where they are worried about a underlying disability, well, it's going to be very fact specific. If they work in a small town in Nebraska where there's only one case of reported coronavirus, it's probably not realistic that the employer would have to accommodate that employee. On the other hand, if they work in South Jersey in what's called a hot spot, where there's a tremendous number of cases and it's exponentially growing, then their concern about going to work might be much more realistic, and a court might support that need for an accommodation. So certainly be aware of the underlying health concerns where you have to engage in an interactive process.
I mean, the EEOC's website and the ABA is supposed to provide broad coverage to individuals with disabilities. So what you're going to see, at least from the EEOC's guidance, is, you know, they're strongly encouraging employers for people with underlying health conditions, the serious types that are, you know, kind of listed, like COPD, heart conditions. They're really encouraging an employer to try to work with that employee and explore whether or not that may constitute a disability. And I think, you know, we've had several presentations on COVID in the last few months with defense attorneys, and you know what we would encourage you is not to throw your own common sense out the window. If you know your thought process is that this may not be a disability, you know, and the individual's just looking to abstain from coming into the office because they're concerned about COVID, potentially because of a health condition, but you have no concern about them teleworking, I mean, you can always avoid litigation and avoid a debate about something if it's not a real issue. You know, so looking to avoid potential, you know, EEOC charges or litigation really depends on how you want to operate your business and what you believe is feasible for you or what's not. As a law firm here, during the midst of the quarantine order, we were able to successfully, you know, allow everybody to work from home. And right now, we're not absolutely mandating everyone to come back, so we're able to work with, you know, different health conditions, et cetera, easily, but other employers may not be in that type of position. So, you know, a lot of defense practitioners are counseling HR individuals and managers to kind of, you know, look at your own business needs and determine what you're willing to accommodate. And the mere fact that you do accommodate someone temporarily in the midst of the heightened concerns of COVID doesn't require that you continue to do it down the line. This particular slide that we brought up, which was, hey, does an employer have to accommodate someone at home with a disability? The answer is no. However, an employer should be mindful that the law still prohibits an employer from potentially discriminating against an individual because they have someone at home with a qualifying disability. So there could still be concerns of what's called associational discrimination, where, you know, in the context of COVID, you divulge that someone's at home who's treating for, you know, cancer, has a weakened immune system, et cetera. And then when they return to work or need to take time off or or have any other reasons for, you know, being in the home, that there's concerns of associational discrimination. So no, you don't have to accommodate for a sick family member at home, but yes, you do have to be mindful that you cannot treat them any differently merely because they have an individual who has a disability.
And a perfect example of that is a case that we accepted last week where a manager had emailed an employee saying, hey, look, we have to let you go. We just don't trust that you're working from home as efficiently as you could be. We know you have an autistic child and we just don't feel like you're as focused as you could be. That was associational discrimination, in our opinion, because the employee was terminated for a perception that they're not dedicated because of someone they're associated with as a disability.
Okay, and we're going to move on to some OSHA realities.
So touching base on OSHA, this goes back to a question from the audience about, do I have to return to work? So there is a section 1977 of OSHA, and that allows an employee to refuse to go to work, and if they're terminated for refusing to go to work, to bring a claim for whistleblower retaliation with OSHA and seek past lost wages as well as emotional distress. It's an extremely high standard. That standard under OSHA requires an employee to actually be able to demonstrate an unsafe environment, not just speculative or subjective concerns. The employee would have to show up. It would have to be an area theoretically where there's a lot of potential rise or current cases of coronavirus. It would have to be a situation where they properly went up the chain of command and tried to bring it to their employer's attention, and the workplace is really unsafe. Either the employer's letting someone who's COVID positive work in the facility, they're not sanitizing an area where someone stopped working because they were COVID positive, they're not following a governor's order with masks or engaging in any social distancing. It's a very high standard, but an employee can potentially pursue a legal claim for refusing to work in an unsafe environment if they've attempted to exercise the chain of command. There's a different section, a section 11C, that actually gives whistleblower rights to an employee. And if an employee says, for example, hey, the governor's order says that I'm supposed to get PPE, you're not following PPE here, you're letting all kinds of people walk around, and they're not, only half of them are following the governor's order, then if you raise a safety concern, whether it's related to a governor's order or whether it's just related to your own subjective concern, if you're disciplined, get a negative evaluation, or you're terminated, that employee has 30 days to file a whistleblower complaint. And even if they were wrong in their safety concern, or even if they were wrong that it violated any regulation or law, if that employee proves that they were terminated for raising the safety concern, they're legally protected. Albeit for some reason, Congress felt it only appropriate to give a very short 30-day deadline.
That's the only thing I want to point out. The reality of a lot of these concerns is the employees, they usually are not aware of what their potential rights are, and they're not aware of the short administrative timelines in which they have to file a complaint with the Secretary of Labor. So, what we see oftentimes is we'll have individuals, more than a month out, several months out, after, they're struggling, they've been separated to, file for unemployment, and the time frame is so short. And what you're seeing with a lot of these individuals, some of the cases that have made headlines with Amazon or McDonald's and some larger workers is, they're trying to bring private causes of action, when they're not able to pursue violations under OSHA as a group for injunctive relief against the employer, or asking courts to accept their argument of public nuisance to rectify some of the concerns. All right, because I'm screen sharing, is there another chat that's active right now?
There is there's some questions being posed. One question, I'll let you field it, Christine. How are the laws different, if any, for smaller or medium-sized companies in light of the COVID situation? Would you recommend to human resources management for these companies to be better prepared, since they are generally limited with resources?
So the guidelines that we've talked about today and some of the mandates, either state mandates or federal mandates, they're no different to, private employers such as a small law firm or a small business versus, a large Fortune 500 company. They have the same, argument to make mandatory masks just by way of a government order. There's no difference. And I don't think that the exposure is every different, because I think you have to gauge your own workplace and the extent to which, like I said, classifying certain workers or determining if erecting certain barriers are appropriate, because you're not going to be sued privately by an individual for a cause of action. For example, like Ari and I talked about, the standard would be pretty high. The mere fact that you get COVID, can you sue your employer for negligence, is a common question. They were negligent in the way that they handled. The duty and the extent of this pandemic is not going to result in liability for employers who are genuinely trying to follow CDC guidance. And so, mentioning the cdc.gov website is important because every single day they're changing what the recommendations are for employers and what the evolving symptoms are of COVID. So previously you were permitted to ask individuals, if they exhibited coughing, fever, which is not always indicative of COVID, but now they've expanded to say you can ask about GI issues, if there's sight issues. So keeping up with what the CDC is recommending is probably the best practice, whether you're a small employer or a large employer, to try to implement or fight against arguments by employees that you're not complying.
But generally speaking, in every state, you're governed by the same standards. There's really nothing we've talked about that wouldn't apply to a company with 5 people or a company with 500 people or a company with 5,000 people. Unfortunately, the ADA, the New Jersey Law Against Discrimination, the New York Human Rights Act, and the Philadelphia Fair Practice Ordinance, and the Pennsylvania Human Relations Act all cover employers with the size of even down to 1 employee for some of those laws, with a minimum of 15 for some of the federal laws. So there is really, it's incumbent upon a company to make sure it dedicates the appropriate resources to limit its liability, which could save it very substantially on the back end. One other question before we touch on the last slide there is that the question was asked, will the waiver of liability protect my organization if my customers get sick? Examples, dance schools, professional services, or sports. So waivers will always carry to some extent, but unless Congress passes a legislation that specifically immunizes your industry, your waiver of liability is certainly never going to be a guarantee. An employee can't waive violations they don't, or not an employee, a patron or a customer can't waive violations they don't know are going to potentially happen. So even if somebody signs an agreement to waive all liability, that will help because they're partially assuming a certain level of risk. But if the business completely dropped the ball, did not engage in any protections, and failed utterly to perform its responsibility to its patrons, then I don't think in that situation a waiver of liability is going to prevent liability. But a good faith effort to comply with protections and a waiver of liability will carry a lot of weight in preventing liability. The last point, which I'll touch on quickly, is the last area of protection for an employee other than OSHA protections is an employee who is told to come to work, for example, in a non-essential business. For example, if things get bad again in October, November, or December, and there's a particular county that's closed, and the employer says, hey, please come to work. We need to make sure that these orders are fulfilled, even though we're not having customers. Well, there is a public policy exception in Pennsylvania, as well as New Jersey, and many other states, that prohibit an employee from being terminated if they refuse to do something that's in violation of a governor's order.
We knew we would probably be getting to the end of our presentation by getting to some of what we see as a hotbed for potential litigation down the line, and some of the most important legislation that's been rolled out in the midst of this pandemic. And FECRA, what it's commonly referred to as the Families First Coronavirus Response Act, is dependent upon the size of the employer. And it seems ironic, but it's for employers that are fewer than 500. So for example, large hospitals or companies like Verizon or the like, this may not apply to them. So it's fewer than 500. And what it requires is it's an expansion of certain paid leave laws that already exist. So we're all familiar with the Family Medical Leave Act, which allows up to 12 weeks of unpaid leave for individuals for their own serious health condition, to care for a family member with a serious health condition and the like, and that's unpaid. Does this require that family medical leave be paid now? The answer is no. What I'm going to get into in the next slide is the circumstances under which, the FECRA laws do allow for paid leave. So any employer under 500 is required to provide this additional paid leave, or up to 10 weeks of a certain amount of an individual's pay for caring for children where their child care facilities may not be open. But if you are a small business, you could qualify for a small business exemption to have to provide some of this leave. to identify you would pose an undue hardship on your business. For example, if you're a mom and pop type shop, or you only have 5 to 10 employees and you believe having to pay 2 weeks of paid sick leave or up to 10 weeks of childcare leave would pose a substantial financial harm on your business, and you would have to apply for an exception if in the event you denied someone that paid leave. Now, this law came into effect April 1st, 2020, and has since been expanded, and it will span through December of 2020. One interesting legal issue that HR individuals are going to have to deal with, which has not been decided by courts and is left unopened, is you're traditionally only allowed up to 12 weeks of leave, and this expands paid leave under the Act and the types of leave that you would be permitted to take. So I'll put that slide here. The question is going to be, what about people who are already out on family medical leave, for example, in the spring of this year for their own serious health condition, if they had been hospitalized or they were caring for a family member and they were already close to burning up their 12 weeks, do they get 12 more weeks of leave? And the answer is likely no. There's no court decision on that issue right now, but there's nothing in our reading of the Act that would suggest that an individual gets beyond 12 weeks under the Family Medical Leave Act. I think the goal was to give some paid leave to individuals that were suffering financially because of the COVID concerns with individuals with health conditions, or the COVID concerns when childcare was being closed. So just to break it down and make it a little bit easier, it's you get 2 weeks of paid sick leave for yourself at full pay if you're unable to work because you've been quarantined or you're experiencing symptoms, or you get 2 weeks of paid sick leave at 2/3 of your pay because you have someone at home that you need to care for, or childcare issues. And then you could get an additional 10 weeks. So that's where the 12 weeks comes in, of expanded family medical leave at 2/3 of your pay because you're unable to work for childcare reasons. Now, the Department of Labor just recently actually issued an opinion about the closure of school camps as kind of expanding the protection, saying that now it's not just your child care is closed, but if you had some kind of anticipated plans to put your child in summer camp, then you could get paid leave where your child's summer care camp is closed. And employers are gonna have questions about, well, how do we believe if someone truly does or doesn't have child care at home? If there's a full-time parent in the home who's able to take care of the child, then the individual may not qualify for paid leave. The question is, can these employees take the paid leave on an intermittent basis? And the answer is, it depends if the employer is willing to agree. So the goal, if an individual is telecommuting and they have a child at home that they have to take care of, is that there's some agreement by the employer and the employee to take the paid leave to care for a child on an intermittent basis if the employer and the employee can agree. If they cannot agree, then the individual has to take it in their block period of, if they need it for 4 weeks or they need it for the full 10. Now, if an individual works on site and telecommuting is not plausible, then the intent was not for intermittent leave to be taken in 1 hour increment or several hours. And again, that would have to be by an agreement of the employer. So allowing individual to take this leave, whether it be for themselves, full pay, and you can look on the website, there's a lot of facts and answer questions in terms of the amount. So there's a max that you're required to pay an individual up to $511 per day, or up to $5,100 a week, depending on how much they earn. For the child care paid leave, the max is $200 a day, or up to $2,000 a week, again, depending what they earn. And there's a lot of nuances to this act. For example, if you have a part-time employee trying to qualify what their earnings are and looking at their hours, pre-COVID, as to what you would pay them now if they're out for child care issues.
And sorry, go ahead.
Go ahead. No, go ahead, Ari.
One other important part to take home is that a lot of employers seem to overlook one critical thing. They think that this is just a normal supplemental pay act, and they don't realize that the FFCRA is an amendment to a federal job protection law called the Family and Medical Leave Act. They don't realize, and they screw up in 2 ways. So an employee might need to take a time off for a quarantine or childcare, and what the employer does is it makes a double mistake. It says, well, we'll just temporarily lay you off and you can collect unemployment. So it violated a federal law that now requires sick leave to be paid, and it separately engaged in a technical termination of an employee when they were supposed to have job protection under the amended Family Medical Leave Act. So the appropriate thing is to pay the sick leave, not convert it to a termination or a layoff. And as a result, you're going to get reimbursed from the federal government dollar for dollar as an employer anyway for any sick leave that you paid in your tax returns. It's very important to understand that if you terminate an employee, even if you're trying to kindly put them on a furlough, you may be violating 2 federal laws.
And we talked just about the Family Medical Leave Act and its expansions here, in terms of a 12-week period. But a lot of you may work over the bridge in New Jersey, or you may operate a business where you're operating in both Pennsylvania and New Jersey. New Jersey, notorious for being kind to its employees and offering certain types of New Jersey family leave. New Jersey has, in fact, expanded its protections for employees by allowing for 12 weeks of unpaid leave for childcare issues. So arguably in New Jersey, you could have a scenario where you have to give an individual 12 weeks of leave for their own serious health condition, and maybe an extra 12 weeks if they can't work due to COVID-related issues and lack of childcare. So if you do operate your business in New Jersey as well and have employees in New Jersey, then you should look at the New Jersey's expansions of their Leave Act, because you don't want to look at this in a vacuum and say to yourself, well, there's only 12 weeks that I have to give out under the Family Medical Leave Act if you do have employees in New Jersey.
Christine, you're asked a question. What are the best resources for us to continue learning about our rights as employees?
The best resource for anything under FECRA is the Department of Labor's website. They try to make it extremely user-friendly for both employers and employees, and they literally have question and answers, any kind of question you could possibly think of, actually. So if you just go to the Department of Labor's website, it'll give you all information about the Family Medical Leave and FECRA. And then for the EEOC's website, you'll get a lot of guidance on the ADA and what obligations you have to accommodate employees, older workers, pregnant workers, and the like. Those would be your 2 best resources. But keeping up with COVID and what the options are for preparing your workplace, I think the cdc.gov website is probably the best place for you to go.
Christine, the last question that was asked was, when making a hire, what can employers do and not do? Example, require a COVID test, paid or unpaid by employer. I'll just quickly answer that one. As it relates to, you have the absolute right to test new employees for COVID, and you have the absolute right to delay the employee's employment and not pay them until they come back with a medical note that they're cleared if they exhibit symptoms or if they exhibit any sort of positive testing. Go ahead, Christine.
Well, to Ari's point, we were just talking about where can you find this information. The EEOC gave guidance on that too. You can actually withdraw or delay the start. You can withdraw a job offer or delay the start of an individual who tests positive for COVID. So again, while not binding, the EEOC guidance gives him information, because you're not declining to hire someone based on a disability. If you run or operate a small workplace and you have an immediate need to hire someone and they test positive for COVID, you could withdraw a job offer, or you could even delay their start time. The one thing I did want to mention, because it is going to become a point of contention between the employer and the employee, and a discussion by managers and HR individuals, is what kind of documents can you ask for an individual who wants to exercise their right to FECRA and stay home with their children, whose childcare facility is closed, or they were going to go to summer camp and they're not now. And the DOL's website says you can ask for documentation that certifies that there's nobody to watch the child. You can ask for the name of the facility where they were supposed to attend childcare, so that you have some assurances that someone's not just claiming, hey, I don't have anybody to watch my child and I want paid leave for another 10 weeks. So you do have some cushioning to ask for documentation, or what's called a certification, where someone just sends something verifying the accuracy that there's no one else that's able to take care of the child. Or if an individual claims that there's been some medical diagnosis or a doctor's recommendation, you can ask for documentation to substantiate that, such that an individual is exercising their right to paid leave under FECRA. The other slides pertain to the CARES Act, which essentially talks about significant funding that the legislature allows for to alleviate the strain of the pandemic on families by providing income to certain households based on certain formulas and the income earned in that household, workers by expanding the potential for eligibility for unemployment and the length of time that an individual could be on unemployment. Small businesses benefited tremendously from the CARES Act, such that, and the act has actually been amended since Ari and I created these slides. The goal was to keep people on the payroll. So small businesses apply for these loans to help run the business, but primarily keep people on the payroll and help pay overhead. Initially, you could qualify for forgiveness of the loan that was provided if you spent 75% of the money on payroll. I think, and Ari, you can tell me if I'm wrong, that the percentage now is about 60-40, that you spend at least 60% of it on payroll. One of the takeaways, though, from economic relief for small businesses applying for a loan to help with overhead and operate funding is, you know, again, the reality is how this all plays out. If you operate a restaurant, for example, and you haven't been able to bring people back until recently, you know, you could offer servers to come back 2 months ago into the workplace, but some people don't want to come back to a small kitchen and be side by side with individuals, or they know that there's not going to be a lot of money to be made and they'd rather just stay out on unemployment. What employers should do when it comes to this loan is to make a good faith offer for their individuals to come back, to document it so you have proof that you ask people to come back to work in their same job capacity, that they would be paid the same thing that they were paid pre-pandemic, you know, when people were on stay-at-home orders. And then if an employee says, hey, I don't want to come back, I don't feel comfortable, or for any number of reasons, then you document their refusal to come back. Well,
just Christine, just because we have a hard stop, I believe, and Tommy, correct me if I'm wrong, I think that we should end just by telling people that the PPP loan has been extended for people to apply and businesses to apply till August 4th, 2020. And I think that we have a hard stop at this point. But I understand the slides and the discussion will be available if anybody wants to obtain it or share it.
Thanks, Ari. Yes, so I think most of us can agree. This has been incredibly informative. I've learned a lot, considering my practice right now is also in the midst of trying to hire new additional staff. So this has been tremendously helpful. If we had 2 hours dedicated to this, we could have done an hour of Q&As alone. So thank you again to Christine and Ari for dedicating an hour out of their day to present this crucial information, because all of us are impacted in one way or another. Just looking at the participants list, I can see that there are a lot of business owners as well as executives that this is crucial information for them moving forward in their respective industries. I want to take a moment to thank everyone for spending an hour with us today and learning about the legalities of the workplace right now due to COVID-19. I want to assure everyone that this recording, even though we did have a technical glitch in the earlier session, will be made available to all members, as well as a slide deck. I will include Christine and Ari's contact information should you feel the need to reach out with any specific legal questions that they can help assist you with. Karpf, and Sruti are premier labor and employment law attorneys, so if you have any legal issues that you want to address, I highly recommend you reach out to both Christine and Ari, and their team will definitely take care of you. I want to thank our participants today. Kindly remind them that we also have a July 23rd webinar coming up as well, Thrive in Your New Norm. We'll also have speakers that are also corporate sponsors of NAP. And reiterating on the fact that NAP does call out as National Asian American professionals, we do not only market to Asian Americans. We welcome all members in the community that want to join our nonprofit to be engaged in these type of sessions moving forward. And we hope when the time is right to see everyone in person again.
Thank you, everyone.
Thanks, everybody.